hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. Our first case of the day is Wheeler versus State of Florida. You may begin.
Good morning. May it please the court, I'm Mark Gruber with CCRC representing Mr. Wheeler. I'm going to try to address two claims today, the one being the ineffective assistance of penalty phase counsel with a focus on the failure to test the defendant's bloody bandages and clothing for the presence of drugs right at the scene of the crime. The other one being the failure to object to victim impact evidence and argument. I'll go to the penalty phase issue first, and perhaps a way of getting into that is to go to the judge's post-conviction court's order, which I pulled a quote from it. He says that the essence of this claim is that trial counsel chose the wrong form of presentation and mitigation. Well, and I'm saying that's getting it wrong about what we were actually trying to do at the post-conviction hearing. We brought in Dr. Smith.
Could you try to speak into the mic a little more?
I hope that's better. We brought in Dr. Smith, whose credentials are very impressive, especially with regard to the issue of addictionology. And his testimony is quite extensive. We also brought in the people that the defendant was with at or before the time of the shooting on February 8, 2005 and February 9th. Now, what the defense did at the time of trial was to bring in more respectable people, the family members, who also talked about an issue with drug abuse and a deteriorating relationship with Sarah Heckman, the defendant's long-term girlfriend.
Well, wasn't it really more than just talk about? I mean, there's a great deal of evidence. I mean, in going through this record and transcript, I mean, it seems as though they really, at trial, presented a picture of a life gone wrong through the drugs. I mean, it wasn't just talk about it. I mean, it seemed to me is that they may not have used a formal expert, but the real life witnesses that testified about what this had done to this man's life was already there.
Okay, yes, sir. Two things about that. What the substantive picture that we're hoping to present, which is different from what the judge says here, is not a lifelong druggie, but rather an individual who, yes, there were precursors, there was indication and risk factors and use of substances prior to this, but getting right to the period, starting about a year in 2004, in that period of time, the drug use right around where he was in Ocala was extreme and especially focused on methamphetamine. And then on a relatively short period of time, starting in October 2004, and then when work began on the house in December of 2004, leading up to the crimes, which were a month or so thereafter, February 8th and February 9th of 2005, what you see is this spiral, what was described as a binge, methamphetamine binge.
Who actually, it seems to me that in this record, we have people who talked about him using drugs and how often he used them, but there seems to be a gap that exists right at the time that he committed this crime. So who actually talks about even in post-conviction, the amount and severity of drugs that he was using just at the time of this crime?
Yes, Your Honor, and actually, thank you for that question. The judge in the sentencing order pointed that out, and in fact, in a footnote, he said point blank, the drugs and alcohol had no effect on the behavior during the crime. We addressed that quite deliberately from the beginning. So we brought in Michael Minton, David Dugan, and especially Sarah Heckerman, and they were individuals who were able to talk about the behavior going right up until the night of February 8th and probably into the early morning of February 9th when the shootings occurred.
And who said he had used, which one of those people actually said he used drugs the day before, 2 days before, whatever, this crime?
Mainly Sarah Heckerman.
Sarah Heckerman.
Yeah,
Now, wait a second. But
Dugan changed the story.
I thought you were going to be talking about the bandages and whether they had meth on them. But are you now focusing on whether he should have put on the 3 witnesses that you put on in post-conviction?
I'm trying to build up to it as well.
But on that one, just on that one.
Okay.
These were all 3 witnesses that the defense lawyer knew about, and I don't see on this record that there is any question but that the defense lawyer made a reasonable, strategic decision not to call these 3 people. And the judge, in the most comprehensive post-conviction order I've ever seen, goes through in detail why it would have been absolutely counterproductive to put them on. So with that, are you going to focus on the witnesses or on this doctor that said that there could have been meth and the bandages should have been tested?
I'm being too circuitous. By the way, they didn't contact Michael Minton, but
You didn't what?
they did not contact Mr. Minton, Michael Minton, who was one of the witnesses that we called.
Did not contact, I'm sorry, for some reason it seems a little muddled. He did not contact which person?
It's harder.
Minton.
For some reason, we're having trouble. I don't know if it's the mic or how you're. I don't know. But you're saying he didn't contact who?
I can amp the voice. Is that any better?
Okay, so who was it he didn't contact?
Michael Minton.
Okay.
Okay, so there were 3 that you called, and you're saying only one of them they didn't know about?
Correct. Now, but let me get to the bandages. What happened with the post-conviction judge followed the state's argument in saying, okay, there were drugs found on these bandages, methamphetamine, and also cocaine and opioid metabolites, and but considered, as I would put it, in isolation, out of context, would not have made a difference in the sentencing
So what
result.
is it that, okay, if we accept that there was meth or opiates, that they say that was also on the bandages, if we accept that, where does that lead us? I mean, we all know, and there was testimony that he had in fact used drugs. So where does that get us that it was on the bandages?
Right to that nexus that I talked about in the judge's sentencing order that said there was no connection between the drug usage that had gone back over the year or basically much longer and the crime, the behavior at the time of the crime. That's what the judge identified in the sentencing order as missing, and that's exactly what we were attempting to address. And the most obvious way to address it would be to go out and get a drug panel from what amounts to a blood draw from the defendant right at the time of the crime.
But the problem is you don't really get from those bandages and what was available the kind of information you would get from a blood draw, which would show the actual concentration and at least potentially would show that. Here, there's just some indication there were drugs. They can't tell how much, and I don't know how that really gets you to where you want to be unless you can tell something about the quantity and therefore the actual influence of the drugs at that time.
Which is why we brought in Dr. Smith and these lay witnesses to show that that connection could be drawn through this downward spiral of the defendant's behavior on this drug binge and backing that up now with scientific evidence, which is the best science could do. I mean, it wasn't because, it was because the science available simply did not allow that kind of quantification.
But what it allows is virtually meaningless. I mean, it tells you nothing than is already known about the fact that this is a gentleman who abused drugs. I mean, that's known. Everybody agrees to that. There's no question about that.
Well, there was quite a question about whether the use of drugs had any effect on his behavior at the time of the crime. And my suggestion, my argument, is that I keep repeating this word, the spiral, deterioration of behavior, and excessive binge-like use of methamphetamine leading up to this event.
I think I hear where you're going, but the problem is, immediately before the shooting, years and months before, he said that if police ever came on his property, he was going to mow them down and go out in a blaze of glory. He said that before and after shooting.
Well, let me narrow it. That came from his aunt and
Brown. Deputy guard.
Well, yeah, those were the words that he was supposed to have said. We have a quibble about the blaze of glory statement, but let me move on from there. The words from his aunt were a period of time before, and as she said, that was when she thought he was beginning to get involved with drugs, or that one of these days Sarah Heckerman is going to bring the police on his property and they're going to start shooting at him and he's going to shoot back. So that became a feature of the state's case and has been to this day. It's there. I agree it's not good. My contention would be that defense counsel could show, using the evidence that we presented in post-conviction, that that would not have happened, that if you look at the defendant's whole life profile from childhood on, this is a person who was a good person, hardworking, getting a family together, building his home, good things to say about him, and it was only in this relatively short period of time, with problems beginning about a year before with the hurricanes and so forth.
Wasn't that's trial strategy? To paint him as a good person?
It was. I disagree with...
And had he brought the other witnesses in that had the 5 felony convictions and drugs and all that, that would have shown that he was according with people who delve in a lot of the illegality?
Yeah, and going back to the judge's order here, that's where I would argue the judge is simply getting it wrong. What we're doing in post-conviction is presenting the evidence that could have and should have been investigated and presented. We're not trying to retry the case.
Well, let me ask you about the what was found in this case. Were both of the mental health mitigators given some weight as mitigating factors in this case?
I believe it was some or minimal.
And what was the basis of the trial judge even considering the mental health mitigators?
Well, yes, and that's what's striking, because the testament, the only basis for it was Dr. Olander, who was the mental health expert that was presented. Her direct testimony occupies initial direct testimony occupies all of 6 pages of trial transcript. And then the cross-examination goes on for 14. Obviously, I counted. And then the judge concluded in a sentencing order that the words were striking, that although the court cannot altogether dismiss Dr. Olander's testimony, it concludes it must give it some weight. In other words, the judge was right on the verge of throwing her out on it.
I mean, was his use of drugs during this time period that you say he was spiraling, wasn't that a factor that played into finding those mental health mitigators?
At this, my conclusion from the sentencing order is no, because of that one footnote where the judge said that drugs and alcohol were not. The factors were stressors from an admittedly very dysfunctional relationship with Sarah Heckerman, that was spiraling out of control, and the stress brought on from the hurricanes, destruction of the house, loss of job, and things like that. Now there's some speculation on my part, but to go back to the point, our post-conviction strategy was to focus on exactly what the judge in the sentencing order identified as missing in the case.
See, but that's the problem I think that you have. What you've done, and you did a good job of it as post-conviction counsel, is you have the benefit of 20/20 hindsight. So you look at the judge's order and say, oh, the defense lawyer should have found more evidence of meth. How can I do that? Let me see, I'll look at the bandages. But we're dealing with whether counsel functioned within the Sixth Amendment as reasonably competent counsel, not perfect counsel. And this idea that a defense lawyer should have said, I'm going to go have the bandages tested, and even, as Justice Kennedy pointed out, even once you get them tested, they're equivocal in their findings. So it seems to me on the issue of the bandages that you got two hurdles. One is deficiency, that I don't see where there's deficiency. And second, I don't see where there's prejudice. It's not like you go, oh my God, this guy was so whacked out on meth that he probably couldn't even, shoot straight, which he was able to kill a police officer and injure another. So, you've got, I appreciate what you're saying, but I think if this is the bandages just don't seem to be a very strong point, which I thought was what you were going to be, that part you were focusing on, and I just don't see where you get either deficiency or prejudice on that.
Okay. Respectfully, Your Honor, leaving aside the issue of quantification, which I agree about, but respectfully, and that's what the judge said, but I really think one of the most astonishing things and that I flatly disagree with is the judge said he wasn't sure whether it was the norm for defense attorneys, and this is back in 2005, 2006, that's not that long ago, to have been interested in testing those bandages. And in fact, the defense lawyers here said they just didn't think about it, and that is the most plausible explanation of why they didn't do it.
Would you, in 2 or 3 sentences then, capture what those bandages establish in this case that make a real difference?
That he was indeed under the influence of methamphetamine in particular, and that it did in fact influence behavior as evidenced by...
To what extent? To what extent?
Well,
I mean, we don't have, do we, scientific, I mean, this is not like DUI studies and when you become impaired and how much it takes, is it? I mean, isn't this just a number that you're talking about?
we have, that's why we have Dr. Smith, a very credible expert, to explain the profile of what happens when people do get into this spiral heading towards a disastrous bottom on one of these binges, and why methamphetamine is especially more dangerous than other drugs.
Generally,
for this
I mean,
type.
he came in with a general description of that kind of, without being able to quantify behavior at any particular time. Isn't that true? Or am I missing?
Well, I don't think you're missing it. I think there may be a disagreement going on in here. I think the combination of an expert who has available to him personal experience and the knowledge of the literature of what people do when they're taking the drugs the way this individual was doing it, and then say, this fella did the same sort of thing.
I mean, again, I think, and you've done, the problem is neither expert could say how much he had used, or really, and this is what you're trying to respond to, but I think you have a deficit of proof, what the effect would have been as those police officers came onto his property to investigate a crime, and he did what he had told his erstwhile girlfriend and his aunt that he would do if police officers ever came on the property. And I don't know how you get beyond that when, with the facts. I mean, you're dealt the facts of this case.
Your Honor, I would really like to go into the victim impact claim a little bit if I could. Before talking about this case, the specifics of this case, where I would talk about the photo montage, the 54...
You are in your rebuttal time.
I am. Oh boy. Okay. One particular issue, the state doubled down here on this argument that the the fundamental error standard for granting relief is identical to the reasonable probability standard. Now, that was discussed below in this court, and the post-conviction court did not employ that argument. The state has now added it into its brief. I'm saying that argument has appeared in other cases that I've seen and has resulted in one in summary denial of a claim. And it's bread and butter for post-conviction collateral counsel to raise arguments about failure to object, which is what occurred here, even though the judge is imploring defense counsel to object. And it's routine for us to address that in post-conviction, and then if the issue was raised and the court addressed the issue as fundamental error and denied it, the state's now arguing we're procedurally barred. And they're borrowing on the Chandler case language in there for that. And I made the argument in the brief, I hope, that the very definitions of the two standards are on their face different.
But in our opinion on direct appeal, did we say that the introduction of this montage of photographs was harmless error?
The court did three things, but no.
What kind of? But we did not find it error, reversible error, correct?
The use of the word reversible, as I interpret it based on reading the briefings, is identical with fundamental error, is identical with due process error. The court did specifically find, with regard to the victim impact statements, that they were not error, fundamental or otherwise. What I'm saying is when I see the court treat one portion of the evidence that way and then another portion of the evidence by saying that it is fundamental error due to counsel's failure to object, to collateral counsel, that's a red flag saying to raise that issue in post-conviction.
But here's the problem, and you're out of time, but this is an important issue. Are you saying, and I don't think we've ever adopted this, and I think we've actually adopted the contrary, that what we have to do is assume reasonable counsel would have objected to the photographs, and that if the objection had been made and overruled, that we would have not been able to find it harmless error, and if we can come to that conclusion, then it undermines our confidence in the verdict? Because I don't think we've ever gone there we certainly haven't done it with closing argument, and I think we would turn a post-conviction into almost a second appeal. Like, assume they should have objected, and if they assume that, we would have reversed it.
If I can respond, I just looked at the other day Cox, C-O-X, which was very, very close in that a similar issue was raised in post-conviction based on failure to object, and this court went on to find, which apparently it had not on direct appeal, that not only was the error not fundamental, but it was not harmless, and then said, and that is fatal to Cox's post-conviction claim. Now that's, I think, sort of the reverse of what I'm saying, but I believe your analysis is correct, that would be the argument that we would argue there's a deficiency in failure to object if the objection had been made, that the claim would survive the harmless error analysis and therefore would have had an effect on the trial itself. And I gather I'm way past my time. Thank you all very much for your attention.
Thank you for your argument.
May it please the court, I'm Ken Nunnally. I represent the state of Florida in this proceeding. With respect to the blood evidence, I think we can dispose of that fairly easily by turning to the trial court sentencing order at volume 5 of the direct appeal record, page 921, where the trial court said in the sentencing order, in response to the proffered mitigation that Mr. Wheeler used drugs and alcohol, the trial court said John DeSantis Jr. saw the defendant smoking methamphetamine days before the homicide. Georgiana Armanakis saw the defendant use drugs days before the homicide. Now, we have that in the record. Nobody has ever said that this defendant was not using methamphetamine. And what the defendant would ask this court to do is Monday morning quarterback, trial counsel's considered decisions not to use Sarah Heckerman, and I'll get to why you don't want her anywhere close to the courthouse in just a minute, why not to use David Dugan, who had 5 prior felony convictions, and not to call Mr. Minton, who had no knowledge whatsoever about Wheeler's actions and activities on the day of the shooting.
Is it correct that they did know about Minton? And just so we can be clear about the difference, because they knew about Heckerman and Dugan, and the trial judge certainly explained why it was either reasonable strategy not to call them. But what about Minton?
I don't remember if they knew about him or not, but it doesn't matter because he is absolutely cumulative to and far from a good witness, because you had...
Well, it only matters in how we evaluate it, because if we evaluate it that they knew about somebody, then it's not even deficient. I mean, if it's a reasonable strategic decision. If it's somebody they should have discovered, then we have to go to prejudice. So that's the only reason I ask you about... I had thought they knew about all three of them.
Minton was completely cumulative and nowhere near as good as the witnesses they put on.
I'm just asking you if they knew about him before.
I don't know if they did or not. I don't believe they did. I think that sounds right. We had so many people involved in this case, it's hard to keep them all straight, to be honest with you. But
we do expect for the lawyers that are arguing cases to get it straight, because we have to get it straight. So
I don't believe they knew about Minton. That's my memory of it. But again, he's cumulative as the trial court found. And the brief at 63 discusses Mr. Minton in detail. And Justice Kennedy, as you said, this is not the equivalent to a blood draw in the context of a DUI case. This is a solution of blood taken from bandages used on Wheeler right after he was picked up or taken into custody. And I believe Mr. Wheeler had been in the lake kind of hiding, and I think my memory is that he was already wet, potentially again diluting whatever blood was on those bandages. And the testing of the bandages to determine whether or not methamphetamine is found in them is, again, cumulative in and of itself. It adds nothing to the case except expense, because it doesn't show us anything we didn't already know and that was absolutely uncontested.
Well, in response to my questions to that, your opposition is saying is that they should have used, if not this particular expert, they should have had expert testimony with regard to that available blood. That's, as I understand it, the real, where he's going on the argument, or to avoid, that's the response to the argument you just made. That's the response I got to my question. So could you address that as to, it's falling below the standard not to have the blood analyzed that was available, and what did that show that would impact this case?
The blood evidence, or the blood analysis, I guess that's the best term to use for it, as I understand the evidence, was something that could conceivably have been done at the time. There's been no evidence presented to show that having this kind of mass spectrometry conducted on this sort of evidence was the standard of practice in 2006, or even today, for that matter. If we were talking about alcohol impairment, that would be perhaps a different thing. That's another case for another day. This is talking about methamphetamine analysis of a bandage used in the field after this man had been shot 5 or 6 or 7 times and was being transported out to a waiting ambulance, as I understand it.
Did the state ever dispute the fact that Mr. Wheeler used methamphetamine?
No. That was never questioned, never challenged.
And so does the record reflect from the trial how often or Mr. Wheeler did use drugs?
Well, in the sentencing order, we have him using drugs shortly prior to the homicide. We have testimony, again, page 921, 922 of the direct appeal record, where Dr. Olander concluded the defendant, quote, chronically used meth, close quote. So that's a long answer to say, yes, we did know, and it was presented at trial about his use of methamphetamine. So
did the state ever present any kind of evidence to counteract any argument that meth was part of the reason that he was having all his difficulties?
No. The state has never contested the fact that he was using methamphetamine. And it's a fact that's there, but let's get to the bottom line with respect to the blood analysis. The most they can say as a result of that analysis is that he had used methamphetamine and I believe cocaine, perhaps, and some unidentified opioid sometime within 30 days prior to the incident. That's the best you get from the blood evidence.
Do we have any evidence or any statement that would indicate that had this analysis been done at the time of trial or at the time that he was in the hospital, that we would have any different result from what we have today? I mean, would we have closer in time been able to have some evidence of what kind of concentration or anything like that, as opposed to having waited until at the post-conviction stage during this analysis?
Short answer, if I understand your question, short answer is no. That's nowhere to be found in the record. The theory, I believe, and I don't want to, create strategy or use strategy for post-conviction counsel, but my impression of their choice of using the bandages from the field is that was the closest in time available to the actual shooting. So therefore, they thought, I guess, that would be the best source to try to get some kind of evidence about it. I suppose. I don't know that for sure. That's what I thought. That's what I've always thought they were thinking, but okay, thank you. But I don't know. But there's nothing in the record about whether you could have gotten a better sample in some other way or at some other time. That's not developed. I don't know that I have anything else I need to say unless.
Well, I think let's talk just on the victim impact issue. There had been a general objection before trial to the victim impact evidence. But then when the evidence came in, and particularly the what we identify as potentially more problematic is in direct appeal, is the state's presentation of photographic montages, presented 54 victim and family photographs mounted on 4 poster boards showing the victim in different settings, holding babies, and we said there was nothing that prevents them from doing it, but the question, and we've never drawn a bright line, but what they're arguing now is that by failing to object at all, there was never any opportunity to determine whether it was reversible error based on a harmless error standard, that is, that it didn't contribute to the verdict. So have we taken fundamental error, because we found there was no fundamental error, and equated that with undermining confidence in the verdict for the prejudice standard? You understand what I'm asking? Is that, first of all, is the fundamental error standard equivalent to saying if there's no fundamental error, there can't be any prejudice under Strickland?
The short answer is yes. Now, let me back up a little bit. The victim impact claims in this case really took 2 parts, and this goes back all the way to direct appeal, where we had the victim impact witnesses who testified, and then we also have these photographs that were introduced. And there
so let's just focus on the photographs.
Photographs all we're talking about, because let's remember, though, that as far as the statements and the testimony, The trial court went through those, and everything the defendant objected to was taken out. So that issue was...
They went through the statements?
Yes, ma'am. They had prepared statements that were going to be read by the victim impact witnesses. Okay. Those statements were reviewed by the court and counsel prior to the testimony. And everything the defendant objected to within those statements was blacked out, not used, taken out altogether completely. So the only thing we really have to talk about is the photographs themselves, which this court said is not fundamental error, and went on to say that Wheeler has not identified the particularly objectionable photographs. There was no testimony about particular photographs. We still don't know which ones are objectionable. There was some testimony at the post-conviction hearing where the trial attorney commented that, well, you know, I was putting in about 40-some-odd pictures myself, and what you have is a finding of no fundamental error. That's what this court found. And if there is no fundamental error, there can be no ineffectiveness of counsel. It just cannot be. The two are absolutely inconsistent with each other.
But don't they address different aspects? One of a case, and I do recall thinking that we have equated it in a closing argument situation, because the argument being, if we're not going to reverse on direct appeal for fundamental error, why would we, years later, consider a reversal based on there's prejudice?
I think that...
And haven't we said, I mean...
I think
that's what I'm thinking.
Have, this
is a friendly question to you. I think it's, again, the idea is if we're going to reverse, we should reverse close in time to when this is going to happen. If we don't consider it fundamental error, then it really shouldn't undermine our confidence in the outcome.
I think that's a fair way to put it. I have never been comfortable equating standards. I'm very uncomfortable doing that because
they're different, because they really do look at two different things.
We're talking about different things. I mean, the fundamental error is something that reaches down into the trial, into the correctness of the trial verdict, and that's not a very artful way to put it, but if you don't have fundamental error, but you can't have ineffectiveness of counsel.
But isn't the fundamental error standard basically that something occurs that vitiates the trial?
Yes.
Isn't that a little different than the standard in the post-conviction process, where what we're looking at ultimately is whether our confidence is undermined? You could say that you might be able to say your confidence is, and the result is undermined, even though you couldn't say it had been the trial had been vitiated. Isn't that so?
Now, that's why I'm uncomfortable with comparing standards. That's why I don't like to do that, and because it has the possibility of 20 years when we're all retired of confusing something down the road. But
well, that's something that other people might be looking at too. I mean, the standard, we need to be very clear about what is the basis for whatever we do here, and not get standards, misapply a standard.
Absolutely. And in this case, the standard that this court has to apply is Strickland, which is deficient performance and prejudice. And in this case, where we still don't know what the objectionable pictures were, and even if we don't have any possibility that those pictures led to the death sentence in this case.
So have they even, and I'm on this post-conviction, shown where the deficient performance was? In other words, did they put on counsel to say, oh, I should have objected to the half of the 54 pictures, and or do we have anything in this record?
Defense counsel testified, and this is going to be another one of those inartful paraphrases, I fear, but defense counsel basically said that he thinks all victim impact evidence of any shape, form, or fashion is inadmissible, but it comes in anyway. And that's because Payne versus Tennessee and the Florida's case law interpreting that in Florida statute. He objected to the testimony, the victim impact testimony, I don't believe he made a specific objection to, he did not make any specific
And
objection
have they
to pictures.
identified for us now, reasonable counsel should have objected to this?
No.
Okay, so
No.
so there's really a failure of deficiency here as well as prejudice.
Yes, ma'am. We don't know what the problem is. We still don't know. But at the end of the day, and you know, I know I've
But
said
I think what the real problem is, and I don't know if you have any more time, but it seems to me the real problem is that you've got these 54 photographs all showing the victim as this really great person, and it really is taking the focus away from what really ought to be looked at a penalty phase, which is, you know, the aggravating and mitigating circumstance. All this victim impact stuff is not an aggravating circumstance, but you can overdo it to such a point that it becomes such a feature of the penalty phase. And I believe that might be what we are being asked to look at, whether all of this really became a feature of the penalty.
Well, none of the photographs in any way were violative of Payne versus Tennessee, because none of those photographs offered any opinion or suggestion about the defendant or the appropriate sentence. None of the photographs became a feature of the trial. There was not testimony about, you know, in great detail about the pictures. Of course, now, and don't forget, the defendant put on his own photo montage trying to show him as a really good guy, too.
Well, he's allowed to do that under the case law that governs this. You know, we do have with victim impact evidence some sort of an anomaly, right? It comes in, but the jury's told it's not to be coming in as an aggravator or a mitigator. Yet, how does the jury not look at who this defendant, who the victim was, and not really their hearts go out to it? So we have an anomaly, but as you say, that anomaly is created by the U.S. Supreme Court and not by
Yes, ma'am.
anybody else here.
That's the law. That's the way it works. But at the end of the day, against these facts that I do not
But we
want,
should tell defense lawyers, they should know that they can object to an excess of photos. I mean, they shouldn't feel like all they have to do is say, I don't agree with victim impact. I mean, there might have, with this judge, if they had objected to certain photographs, the judge might have limited, because he really acted very moderately in balancing things. So, you know, it's not an all or nothing.
but at the end of the day, even given every possible benefit of the doubt to the defense, those pictures didn't earn this defendant a death sentence. His own actions on February 9th of 2005 is what landed him on death row. The facts are well known to this court, and the facts, quite honestly, are horrible. This court knows what they are, and this is a death case. This is a case in which death is undoubtedly the appropriate sentence, and there was no prejudice to the defendant from these photographs or any of the other victim impact evidence. With respect to the other issues, the state stands on its brief and asks the court to affirm the denial of post-conviction relief.
Thank you for your arguments. The next case on their docket for the day is Barnes versus State of Florida.
May it please the court. My name is Richard Kiley. I work for CCRC Middle, and I'm representing James Barnes in this action today. I would like to argue Claim 1 in Mr. Barnes' 3851 motion. Mr. Barnes' rights under the 6th, 8th, and 14th Amendment to the United States Constitution and the corresponding amendments to the Florida Constitution were violated during the guilt and penalty phases of this trial. standby counsel was ineffective in failing to move for a determination of competency to proceed, and the trial court erred in not conducting a hearing to determine if Mr. Barnes was competent to proceed.
Counsel, let me ask a question. I'm a little puzzled by the argument based upon the development of the law with regard to standby counsel. My concern would be, and I would ask you to articulate the rule of law that should be followed when we look at the law that directs that standby counsel not become involved in the case unless requested by the party in the litigation. How does that square with the argument that you're making, and how do we draw the distinction?
Well, it is my contention that standby counsel was appointed as standby counsel prematurely. Now, Mr. Barnes, he waived counsel. He was indigent.
Well, it seems to me those are two different, really distinct issues. The question of whether you discharge counsel or whether what the standby counsel did was appropriate. That really seems like two very distinct issues that we must deal with. So which is it that you want to assert here? I thought it was your argument that standby counsel violated the duties of standby counsel, not...
No, well, Your Honor, actually, this is a substantive due process claim, and we're saying that the rules of criminal procedure, it is cited in my brief, in my motion, that anybody in the courtroom, the state, the defense, the court on its own motion could have, and we are contending should have, ordered a competency evaluation. Now, this woman in the courtroom with Mr. Barnes was allegedly an experienced felony, not capital, public defender. And when Mr. Barnes came in and said, I have borderline personality disorder and I've been Baker Acted in the past, it would have been prudent and necessary for them to appoint two doctors.
Why wouldn't that have been a direct appeal issue?
Well, Judge...
I mean, you're pointing out that in this record, there was evidence that that the competency evaluation should have been ordered. That's a direct. Why isn't that a direct appeal issue?
Well, first of all, Judge, James v. United States. No, I'm sorry. James v. Singletary differentiates between a paid claim and a substantive incompetency claim. This is a substantive incompetency claim which can be raised by anyone, and it doesn't have to be raised on direct appeal. I would also cite for additional authority that this issue is not procedurally barred, and I would cite Massaro versus United States, 538 United States 500, 2003, which holds that an ineffective assistance of counsel claim may be brought in a collateral proceeding, whether or not the petitioner would have raised the claim on direct appeal. And
I would like to get to what is in this record, other than him saying he had been Baker Acted at some point, that would have, what actions on his part would have led either the standby counsel, the court, or anyone else in the courtroom, as you indicated, to say that this man was incompetent? What actions on his part?
Well,
what actions on his part indicated that he was having?
But he admitted he was borderline personality disorder.
I understand that. I am saying what actions on his part would have led anyone to believe he was incompetent at that time, other than what he said happened in the past. What was happening right there in the courtroom that would have led someone to believe he was incompetent?
At the time, probably nothing but his words. However, Your Honor, during the proceedings, most notably the Spencer hearing, when the trial court moved to have Mohammed counsel appointed, Barnes, pursuant to someone with borderline personality disorder, chastised the court, chastised the state, and refused to cooperate.
But you are saying that there should have been a competency hearing before even the penalty phase, correct?
Correct.
So that's the actions I want to know about. what actions at that point would have led any reasonable person to say, this man needs a competency determination?
Your Honor, respectfully, I ran a PD docket for 14 years, and this happened routinely. When someone would come in and said they had a mental illness, they've been Baker acted, put the brakes on it, appoint 2 doctors, and then we'll proceed. They had plenty of time to do this.
Appoint a lawyer for him, and he basically, as he said, chastised the judge.
Yes.
And said, why do I need a lawyer for? I got a state attorney.
Yes.
And I guess what you're saying is that he thought the state attorney would be in charge of bringing out the mitigating evidence.
That is also
And
correct, sir.
and that's your point in saying that that right there should have been sufficient reason to believe he was not competent.
No, also, Judge, I would say that when the court appointed Mohammed counsel, Mr. Barnes chastised the court for being unprepared. Now, which gives an indication that he had no idea what Mohammed counsel was for. Although Barnes was a certified law clerk, his experience was in regular run-of-the-mill felonies. But I'm saying at that point in time, they should have definitely said, oh, he doesn't understand the proceedings, let's appoint 2 doctors to determine competency.
Well, it seems to me that we go through a lot of proceedings. Or often than not, they really don't understand the proceedings, but they insist that they want to represent themselves and they want to handle their case themselves when they know nothing about true cross-examination. They know nothing about objecting when there is something to be objected to. So in all of those situations, because they don't know that, we should do what?
Well, you know, it is my contention, quite simply, that this case is governed by Hamlin v. State. It's almost identical. Hamlin, after a grand jury indicted him, his public defender moved for a psychiatric evaluation. Both doctors reported that Hamlin was competent and was legally sane at the time of the offense. Upon receiving news of the doctor's reports, Hamlin asked the court to revoke the public defender's appointment and allow him to represent himself. He had simultaneously announced his intention to plead guilty, as did Mr. Barnes. And in the field of criminal law, there's no doubt that death is different, but in the final analysis, all competent defendants have a right to control their own destinies. But they didn't make a formal determination that Mr. Barnes was competent.
So now you're really arguing that in every case, and this might be a good rule for in a direct appeal to consider prospectively, in every case where a defendant in a death penalty case wants to represent himself and or waive mitigation, that in addition to what we have put forth in Mohammed, we should have another rule that also says, and we should determine their competency. Is that your argument? I mean, because in this case, because this isn't that, there's nothing that he did in this case that's particularly, as Justice Quince points out, different than in other death cases where a defendant decides really that he wants to die. And the only thing that happened differently in this case is the judge scrupulously followed Mohammed, appointed, had a PSI, appointed a lawyer to put on mitigation, so we really have a fuller picture of this defendant. But I just don't see where you're going in a post-conviction motion about the fact that in this case it was a denial of due process or a substantive violation not to have a competency. So maybe just give it one more shot about what is it, are you asking for a rule of law for all cases or saying there's something particularly compelling about this case that would have required the judge to have ordered a competency?
Well, Your Honor, I would say that this case, the signs of insanity or incompetency were prevalent.
Now are you equating insanity and incompetency?
All right. competency, Judge. Mr. Barnes suffers from borderline personality disorder. That is basically when someone goes from the neurotic realm into the psychotic realm, and it's exemplified by a distortion of the emotions. For example, a normal person who would be mildly peeved, Barnes would fly into a rage. A normal person who is mildly embarrassed, Barnes is abjectly humiliated. And you can see through the course of the proceedings, Mr. Barnes gets unreasonably angry with the court when the court was, in the interest of caution, appointing Mohammed counsel. He refused to, and he had every right to do that. But we had to make sure, we should have made sure that this man was not competent, was competent at the time he entered his plea.
What have you shown on post-conviction that would have indicated that that should have been done? Seems to me that in post-conviction, didn't we have two experts examine him in post-conviction?
Yes, we did, Judge.
And did they both say that he competent?
Yes, they did. And the reason I wrote that motion was Mr. Barnes refused to relate to us at all. He refused to come down. He didn't come down for 7 months. And when he came down, I think I met him twice. When he came down, all he did... Came
down to what?
Down from the cell block to the interview room. And when he came down, all he did was spew invective at us personally.
Well, it seems to me that that's in keeping with he didn't want a lawyer before, and then maybe he doesn't want one now.
Well, Judge, what we conveyed that to Judge Griesbaum during a status conference, saying we can't meet with the man, we can't help him. And Judge Griesbaum said, well, we're going to bring him down here to see if he wants to fire you. Mr. Barnes then sent us a communique.
And he said, no, he didn't want to fire you?
No, he said, don't bring me down to court. I have multiple sclerosis. So we went up to UCI and said, if we can have you sign this medical release, we can prove to Judge Griesbaum that you have multiple sclerosis. This was way before the motion was signed. He said, no, I lied. I don't have it. So we brought Mr. Barnes down after I had written the motion saying he will not cooperate with counsel. He doesn't even understand what we're supposed to do. He cannot help us.
Well, because isn't it a fact that Mr. Barnes really wants to, I mean, does he want to proceed with this post-conviction, or does he want to waive his post-conviction proceedings and be ready to be executed?
We gave him a chance to fire us. Now, Mr. Barnes had converted to Islam, and he believes that waiving his post-conviction would be a sin. It is evidently a sin under Islam to kill yourself unless you're taking an infidel with you. So Mr. Barnes does not want to actively participate in waiving, but he wants to die.
So really, the only issue we're dealing with here is whether he's competent. The judge found he was competent to assist you in post-conviction, which was of little help, right? Because your only claim was about whether he was competent at the time of trial. And I'm still trying to get a notion of if competency at the time of trial was an issue and it was apparent on the record, I don't know how you get to bring it up now as opposed to whether it should have been brought up on the direct appeal.
Well, Your Honor, we were asking for an evidentiary hearing where we're going to bring in the public defender to say, didn't you see this man and try to enter a plea to capital murder? And didn't he tell you he had borderline personality disorder? And didn't he say that he was Baker-acted in the past? Why didn't you move for competency?
Is there a different standard of competency for someone who is pro se compared to someone who is represented by counsel?
I would say no. I would say no, sir.
But one of the issues is there was whether he could have discharged counsel for Ferretta hearing, and that was had, correct?
Yes.
All right. But then there was the plea. Was he represented by counsel at the time of plea?
He was not.
All All right, so now are you saying the plea should be, you should go back on an evidentiary hearing to see whether the plea should be set aside?
On an
He doesn't want to set aside his plea, does he?
I think he should be given the opportunity to set aside his plea, but I would.
On the basis of what? I mean, if he's made no claim that he wants to set aside his plea, what would be the basis for us, sua sponte, saying he should have that opportunity to set aside his plea?
Upon, well, pursuant to Hamlin, upon a formal determination of competency, which was done by Dr. Bernstein and Dr. Danziger, they found him competent. If he wanted to reinstate his plea, he could. If he changed his mind, which borderline personality people can do, he could have opted to go to trial, plead, or have a jury for his penalty phase. There was considerable mitigation that was uncovered. Barnes didn't want to use it at that time. Maybe he wants to now.
You are your rebuttal time. I'm sorry.
Well, it just seems to me that your whole argument breaks down to, let's give him another opportunity to decide what he wants to do without any real basis for determining that what he did before was incorrect. I mean, that's what it really sounds like you're asking.
Respectfully, Justice Quince, I would say that we do have a basis. His self-reporting that he's borderline personality and was Baker acted. That is a basis to determine his competency pursuant to Hamlin.
And in this new evaluation, that they found him borderline personality but competent.
And yes. Yes.
It seems somewhat confusing that the evidence you put on is that he is competent. Am I correct in that? Is that the evidence you put on at the in post-conviction?
We didn't get any.
Well, I mean, I thought that's what your argument was, is that that's going to be the in line here, that he was examined at some point, and that he's competent.
Yeah, and now, Your Honor, since there has been a formal determination of competency pursuant to Hamlin, he should be allowed the option of either withdrawing his plea or re-entering his plea. That's all I have, Your Honor. I mean, I can't make the facts, and if I could, I certainly wouldn't make these up. Your Honor, I'm into my rebuttal time very seriously, and I would request to be able to rebut. Thank you.
May it please the court, I certainly sympathize with Mr. Kiley's predicament here. He's got obviously a very difficult client. The evaluations in connection with the post-conviction proceeding showed that this defendant, Mr. Barnes, was diagnosed with a personality disorder not otherwise specified, with antisocial and borderline features. There is no question about Mr. Barnes' competency. There is nothing to suggest that Mr. Barnes has ever not been competent. And what we are being asked for, I think, is a per se rule that any time a defendant makes mention of having been Baker acted at some unspecified point in time.
Did either of these doctors confirm that he had been Baker acted?
I don't believe they did. But of course we all know you can be Baker acted for reasons that have absolutely nothing to do with competency. And we don't know for sure even when this Baker Act proceeding took place. We don't know. It's not there. But like I say, a Baker Act proceeding can be the result of many things, most of which have nothing whatsoever to do with competency to stand trial or competency to waive counsel. And, you know, as you pointed out, Justice Quince, a lot of people come up here, not uncommon for defendants to want to waive counsel and represent themselves, and the issue is not whether they're a competent attorney. The issue is whether they're competent to make that waiver or make that decision to waive their rights under Ferretta, and this man was competent to do that.
Do we I mean, is this an issue of it being procedurally barred, or just that there is no additional evidence? They're saying they should have had an evidentiary hearing to put on, I guess, additional evidence that he actually was not competent at the time that he entered the plea and waived mitigation.
Well,
Is this, so that's the
okay.
question.
The bottom line is the claim is procedurally barred because it could have been but was not raised on direct appeal. In this case, what we have, by the way the case developed, we have in fact evidence about Mr. Barnes' competency in the form of reports from Drs. Reeb, Same, and Bernstein, I believe it was, who both said that he is in fact competent. And they're the ones that made the personality disorder NOS diagnosis of him. That is extra, if you will, to the ultimate disposition of this case, because the competency claim, or the claim that the trial court should have sua sponte raised competency and conducted a competency determination, is a direct appeal issue. It could have been raised then, and because it was not, it is procedurally barred. That should be this court's first basis for disposition of this case, is the procedural basis. The 3851 competency determination or evaluations by the two psychologists is fortuitous in this case because it demonstrates that Mr. Barnes is in fact competent, and there is in fact no evidence ever anywhere in this record to suggest or imply that Mr. Barnes is in fact not competent or ever has in fact not been competent.
Well, I thought part of their argument is that they wanted to bring, at an evidentiary hearing, bring in the standby counsel to question her about Mr. Barnes's actions, which would have led a reasonable person to ask for a competency determination.
Well, standby counsel, that is, I suggest, creating an issue out of whole cloth that doesn't exist under the Constitution. To do that, this court would have to extend the Sixth Amendment to standby counsel. Now, which the defendant has no constitutional right to at all. So we're leaping over a couple of hurdles here to try to create some basis for some sort of a claim. But I believe this court's already said that an ineffectiveness claim as to standby counsel doesn't lie.
I think what we have here, and I appreciate that CCRC is in a difficult position. We see this with these defendants that sometimes we call volunteers, when it doesn't look like this defendant is actually trying to manipulate the system by saying, I want to stop things, but I don't, back and forth. But what we have now is somebody that if a death warrant were signed, what is it that we need to do to put a sort of an end to that this doesn't keep on going on with a defendant that really doesn't want to be actively represented? And so that, what do we do? What does the state do? Does the state report to the governor, this is somebody that's ready for execution? I mean, how do we deal with this so that we don't deal with this defendant for the next 20 years?
I'm afraid the policy questions may be above my pay grade, but in this case, and I mean no disrespect by that, because
well, I think the state does have an obligation.
Yes,
we see many defendants, and this one is in an interesting situation because he's apparently, because he's converted to Islam, he's not going to waive his post-conviction, but we're going to just sit there and sort of, what are we going to do with this defendant?
In this case, now I know nothing about Islam. It's the first time I've heard this. I don't know anything about the the strictures or tenets of that of Islam. I have no knowledge on that subject. But I do know what we have in this case is a claim that is procedurally barred and was so found by the trial court. This court should affirm the denial of post-conviction relief as it stands, and the case needs to go on from there. If Mr. Barnes allows the time for filing his federal habeas petition to pass without filing, then the state will certainly make the appropriate notifications at that time, and we will certainly do the appropriate thing when that time comes. I do not know how much time he has remaining. I don't calculate that until it becomes an issue I need to consider. But in this case, this claim is procedurally barred. As far as the competency issue is concerned, we have the added benefit in this case of the 3851 competency proceedings that completely eviscerate any suggestion that this man is in fact incompetent. And we have on top of that an ineffectiveness of standby counsel claim that simply does not state a claim that relief can be granted upon. And in this case, the state's position is this court should affirm the denial of relief, and the case can move forward as it does. With that, I would ask the court to affirm the denial of relief if there are no further questions.
Thank you for your arguments. Rebuttal.
Briefly, first of all, regards to the two doctors who determined competency. Dr. Danziger reported on page 4 of his report, he made one suicide attempt when he was 28 years old, although he did not discuss that in any detail. Barnes was born in 1962. He reported to the court that he was Baker Acted in 1980. That would make him 28 years old at the time. Second of all, in regards to volunteers, this court has already done that. I represented Eileen Warnos, and this court, when she volunteered, sent the case back to Judge Hutchinson in Daytona Beach to determine if she was competent to waive. There had been a prior determination of competency in the Ocala case, and she was allowed to waive her appeal. So this is nothing new to this court. This court has done this before with volunteers. Newt Lawson's the same thing. In regards to a pro se rule, no. I'm not asking for a pro se rule. I'm just saying, and I would not have brought in additional evidence of competency. I would have merely taken the alleged experienced PD and pretty much said, what were you thinking? Why did you let this guy enter a plea to capital murder without first determining if he was mentally competent to do so? So just that's where we stand. I'm not asking for a pro se thing. I'm just saying that since there has been a formal determination of competency and Mr. Barnes is competent, he has a right to control his own destiny, we should ask him again. Maybe he's changed his mind. I don't know. That's all I have.
Thank you for your arguments. The court will now be in recess for 10 minutes.
All rise. All rise. Supreme Court of Florida is now in session. Please be seated.
Our last case for the day is Special versus West Boca Medical Center. You may proceed.
May it please the court, I am Philip Burlington here on behalf of Frank Special, who is the petitioner and was the plaintiff below. This case arises out of medical malpractice action, and the issue before the court is what is the harmless error standard in civil cases in Florida and how it is to be applied in this case.
You agree that even if we follow D'Aguilio as a criminal case, that the standard has to be adapted for a civil case?
It's our position that the standard should be the same as it is for criminal cases. And
but if you read D'Aguilio, which is based on Chapman, and you read Chapman uses the reasonable possibility language as a equivalent to beyond a reasonable doubt language. And so my concern is that we don't want to import a standard from a criminal case with constitutional implications. I mean, I agree that with other aspects of what you've argued, but I'm just concerned that we've got to look back at how D'Aguilio came about. Why wouldn't the standard, at least as far as the burden of proof for the party who is the beneficiary of the error, be slightly different because it's a civil case?
There was an excellent discussion in the federal Third Circuit case called McQueenie, in which they consider the arguments for and against that proposition and conclude that it should be the same standard. And what they determined was that there are basically two arguments for saying there should be a different standard, civil to criminal. One of them is that the burden of proof is different, as you indicated. However, as discussed in that case, while there may be a facial symmetry in saying that the burden should be different in a civil case with harmless error as to the burden of proof, there's no logical symmetry, because the burden of proof in criminal and civil cases to prove the claims are a reflection of society's concern for the certainty of criminal convictions, which can result in the deprivation of liberty or, as we've heard earlier today, possibly life. However, the burden as to that issue does not correlate or reflect society's concern for the level of error they are willing to tolerate in judicial proceedings. There simply is no logical connection. And in fact, in the Third Circuit case, it says that to make the leap to say that the harmless error standard should be different would compound society's supposed concern without any real logical basis.
Well, I guess but and I'll look at the Third Circuit case. My concern is this. First of all, unlike a criminal case where it's the defendant who is going to be arguing that something isn't harmless and the state has, as the beneficiary of the error, has to prove that it was harmless beyond a reasonable doubt, right? That's what the state has to do. Here what we have is the idea that, first of all, you might take technical errors in a trial and you don't want a reversal just because of a technical error, but we're going to be applying a standard that goes both ways, right? Plaintiffs and defendants, as you say. This is not a plaintiff-friendly or a defense-friendly argument. This is really looking at the level of error that you want to tolerate, and I'm not sure why it isn't, and again, I'm not, this is just trying to understand it, why it's not a better policy argument, since it is going to go both ways, to say that the party that is the beneficiary of the error needs to prove more likely than not that the jury verdict would have been different, and that's for either side. And I'm not sure, really practically speaking, whether saying more likely than not versus reasonable possibility is going to change things too much, because appellate judges sort of, and if you see criminal cases, you'd know this, they sort of can say, and we find it harmless beyond a reasonable doubt, and that's the end of it. So I guess, and that might be the other question, is how do you see functionally the difference of saying a reasonable possibility is so different from saying more likely than not?
Well, if this court deems them equivalent, then you're sort of essentially using
well,
the
it's
same
just I'm not
standard.
seeing them too different, because they're talking about some courts use may have had an effect, the others use probability, another use possibility. Now we have more likely than not. I'm not sure, as the brain of the appellate judge is working through this, that it's going to mean in real life that much of a difference.
As the court in McQueenie noted, if you do the analysis that it should be the same as the burden of proof, then in civil cases where the standard is clear and convincing, then you're going to have to use another different standard for harmless error. But in the way of the practicality
and that's true.
of
That the Jimmy Rice Acts would have to
Excuse
be.
me?
In Jimmy Rice Acts, you would have to have a different one.
Correct.
Right.
So if we are going to say it has to be symmetrical with a burden of proof for factual issues in the trial court, then it will have to be variable depending upon the nature of the case. Even amongst the civil, there'll be variation. But as to the practical effect, it is very difficult to establish any standard that is going to do anything more than guide diligent judges to apply a uniform test. And candidly, part of the problem is that obviously we are all concerned with the appearance of uniformity, predictability, and if we have cases that use a variety of standards, as we currently have now, and as the Fourth District's opinion clearly elaborates, there is the perception when certain districts use more than one.
No, I have no I mean, I think we need to have one standard, use the same words, whether the appellate judge interprets it differently, we can't control. But so I think I just went to the question, what's wrong with the more likely than not standard versus reasonable possibility? That's really all my...
well, it certainly is a more strict standard, and presumably that would factor into the admittedly complex discretionary calculus that appellate judges would engage in. But I cannot tell you anything clearer than that as to how it would change. It would mean there'd be more reversals, presumably.
Well, you obviously think it will make a difference on whether this case should have been reversed if we use reasonable possibility versus more likely than not, or you wouldn't be up here on it.
Well, certainly I would like a more liberal standard today. And I would add that I do believe that the Fourth District was wrong in concluding, even under the standard they adopted, that we did not have a situation of harmful error. Their summary of the evidence that was excluded is frankly a little truncated, because they essentially presented as we were allowed to argue these statistics in our closing argument. That's the equivalent of having cross-examination of their expert. But what is not pointed out in the opinion is that what we were able to get in the proffer through the cross-examination of their AFE expert was that if the numbers as testified to Dr. Adelman existed long-term, and Dr. Adelman admitted it was over 17 years that he had 1 to 2 a year, that not only was it 20 times the regular rate, but that he would have to acknowledge the probability that they were over-diagnosing AFE. And there is that testimony exists nowhere else. In fact, Dr. Adelman, when asked about it, although he acknowledged that it would indicate a higher frequency than the national rates, he specifically denied it indicated overdiagnosis. And because of the uncertainty regarding this condition, it is clearly one that is not understood. It is a diagnosis of exclusion. It is only to be reached when the practitioner eliminates all other reasonable diagnoses. They do not know, and the jury would not know. Does this indicate, is this something that could be subject to environmental clusters like we see lawsuits all the time about certain areas being prone to things because of leakage in their water? There was no explanation of that, and that was absolutely eliminated.
But isn't the explanation is that he was talking off the top of his head about numbers, and is there any evidence that the numbers that Dr. Edelman said had any basis in reality?
They had basis in his personal experience.
Well, I understand that he said it. I don't question that. But is there any information that backs that up otherwise, that they, whoever they happen to you're talking about, had made these determinations that AFE had occurred at this hospital and these numbers that would be well out of line with what would be expected based on the general experience?
He testified that he personally made this diagnosis 1 to 2 years. He was the pulmonary specialist. He was the chairman of the hospital board. This is a man who claimed
But there would be
to
documentation about that, wouldn't there?
Excuse me?
Wouldn't there be documentation about that? But what you're telling me is you have no documentation about any of that.
Well, we would, I guess, have had to ask a very broad discovery request for all medical records.
I've seen those before.
Excuse me?
I have seen such broad requests before.
Right, but when you have the person who made the diagnosis in this case testify as to their personal experience, and that 1 to 2 times a year for 17 years, he, as the pulmonary specialist in the hospital, as the person who made the diagnosis, he did it that many times, it was admissible evidence. Nobody's ever challenged that. And he's the one making the diagnosis. He's the one we're challenging. So regardless of whether we have to do a statistical study.
I don't understand. You say you're challenging him. He's not a defendant in the case.
No, but he was
your witness. Is that correct? You called him as a witness?
Well, he was an adverse witness. You can clearly see from his testimony he's an adverse witness.
But the defense was not relying on him on the issue of liability in this case.
Well, they had to because he testified.
What do you mean they had to?
Because he testified it was his diagnosis. He is the pulmonary specialist.
But what his diagnosis is not the question. The question is what condition existed. What happened? Isn't that the question?
No. The diagnosis is critical. Our theory of liability was that there was a problem with anesthesia. It was done too high on the level. It affected the respiratory system of the decedent. When it went down,
I don't see how what Dr. Edelman's experience and what he thought about that after it happened has to do with whether it happened the way you said it happened.
Well, we're not challenging this testimony does not challenge whatever factual testimony about this incident. But this was an incident where it was admitted that there was no evidence on autopsy. So they say only 25% of AFE patients result in no signs on autopsy. Additionally, there was no pulmonary edema. Testimony was that happens in over 90% of the cases. We are trying to prove the fact that this was not a proper diagnosis. And when the person who made that diagnosis testifies as to his personal experience, and his personal experience vastly outnumbers...
To shift from this a little bit, what was your theory about what caused the patient to kind of spiral downward in the way that she did? What was your theory about actually what caused it if it wasn't AFE?
She was given a spinal anesthesia. It's our position it was done too high on the spine, and in that situation what can happen is you can eliminate the ability of the respiratory system to function, and that caused the respiratory system to break down, and they did not respond properly, and that sent her into a cardiac arrest, and that the code was not handled properly with respect to fluids, epinephrine, and other specific treatments. That was our theory of the case. Their defense was, oh, this is AFE, you can't do anything about it. When this hits, she's dead. I mean, there's really nothing they could do. So we had to attack that diagnosis, and the misdiagnosis was critical to eliminating their primary defense. Now, they did defend on the theory that everything we did in anesthesia was proper, but the AFE was clearly...
But what did the plaintiff put on Dr. Edelman?
We put on Dr. Edelman...
because what you said was, what I thought, that it was sort of attacking the defense by saying that all these doctors rushed to the judgment that it was AFE even before there was an autopsy.
Correct.
So you really, I think the question that Justice Kennedy asked earlier, you really put him on so you could cross-examine him on this overdiagnosis. Isn't that what the reason he was put on?
Certainly we did, in anticipation.
So he was he wasn't a helpful, he was an adverse witness because you were trying to disprove the diagnosis that he gave is of AFE, and you cross-examined him, and you were allowed to cross-examine him fully on the fact that he, probably in this hospital, that he was overdiagnosing AFE, right?
Correct.
Okay, so now going back to the harmless error issue, I guess if we look at the proffer, because that shows whether if that had been used, whether there was any reasonable possibility of a different verdict.
Okay.
Okay, so you're saying we look at that proffer, and if that proffer and the cross-examination had been done, how is there a reasonable possibility of a different result?
Because their AFE expert, who said, oh, this was AFE despite the fact there was nothing on autopsy, no pulmonary edema, he admitted in that proffer that if these numbers were accurate, and we got the number of births annually from the hospital itself, so that's not at issue, then he would probably have to admit that they were overdiagnosing the condition.
But his opinion that it was AFE was not based on the doctor's diagnosis. It was based on clinical things that you haven't contested about what she looked like at the time of the spinal anesthesia, right? There were things in the record that he based it on. He wasn't basing it on Dr. Edelman's diagnosis.
Yes, he was. If you look at his testimony, one of the things he relies on heavily is he says all the physicians who were involved concluded it was AFE. This was a totally clinical diagnosis, and he relied heavily on that fact. And Dr. Edelman...
And I think we're not really, no one's argued that it shouldn't, well, someone is, but that it wasn't a proper subject for cross-examination. I'm just trying to see how there's a reasonable possibility that if he had then been confronted with the 2 a year, which I also seems to me like a guesstimate, not really based on any actual facts in the record, that jury would have said, oh my goodness, this really wasn't AFE, this was an overdiagnosis. They'd already established that through the cross-examination, and they were permitted to argue it. And so when we look at harmless error, we do look at what the jury did here. And so I'm having a bit of a problem with how it's not harmless error.
Dr. Adelman was the one who diagnosed it. He's the pulmonary expert at the hospital. Our theory on this was that they overdiagnosed at the hospital. He's the lead guy. The other doctors followed him. That he was the one who said 1 to 2 a year for 17 years.
And that came into evidence.
Excuse me?
It came into evidence, and it was right, and he was cross-examined about that, or examined about it.
Yes, but he denied that it indicated overdiagnosis. Their expert conceded that it did reflect overdiagnosis if those numbers are accurate. And this undermines not only Dr. Edelman, who was the leading, if we hadn't put him on, they would have claimed we didn't prove our case because we didn't put on the doctor who diagnosed it. And he was the one who said, he admitted it was 20 times. I think the expert said it was 30 times the national average. So even if you give a fudge factor to his numbers, it's still way above the national average. And this is a diagnosis of exclusion, and I would like to reserve whatever I can.
Before you sit down, would you please address whether there are any Florida statutes that ought to be considered in reaching the conclusion with regard to whether the standard, not the burden, but the standard, from criminal and civil cases ought to be the same, ought not be the same, and why?
Well, 1911, obviously, the 59041 was passed. That applies to civil. 39 was the 942 statute, criminal. That one talks about whether it prejudices the substantial rights of a party. In 1976, they passed the evidence code, which included another statement regarding harmless error. So the most recent expression of the legislature as to civil cases is in the evidence code, and it virtually tracks identically the language of the criminal statute, which says if it has to adversely affect the substantial rights of the parties. So, and I would also add there's some case law, although it's in the context of certiorari cases, that holds that the phrase miscarriage of justice is to be construed as where there's adverse effect on the substantial rights of the parties. So I believe there's a uniformity, albeit there is perhaps some variation in the oldest expression by the legislature, but as to the most recent one is virtually identical. Thank you.
Good morning, Irene Porter, arguing on behalf of Dr. Box and his medical associations. We've agreed to share our time with West Boca's counsel. We still maintain that the evidence was properly excluded. We recognize that the 4th District disagreed with us, but the facts on why we maintain it was properly excluded and why it was, if it wasn't properly excluded, also show why it was harmless. There was no claim in this case that Dr. Edelman's diagnosis after the fact was negligent or caused any harm to the patient. The claim was solely as to anesthesia complications and whether the anesthesiologist did something correctly.
Well, I mean, it was. What was the cause? I mean, that's
Yes.
the case is about. What was the cause of this individual's death?
Yes, and my point is, was it anesthesia complications and negligence, or was it the AFE? But no one was claiming that what Dr. Edelman did or didn't do when he decided, in his opinion, when he was treating the patient, there was AFE, that caused any harm to this patient.
No, I don't
There
think
was no
that's,
claim.
and I know you realize what it is. It's not that. It's that if you have AFE, there's no malpractice. So the idea that if in a particular hospital, every time there's a death, and without even waiting for the autopsy, they argue, they say, it's AFE. They sort of jump to this conclusion. The idea that they're overdiagnosing it leads a jury to think, you know what, we're questioning this diagnosis that Dr. Edelman gave of AFE because he's always doing it. He's been doing it for the last 20 years. And so he's coming in to help his fellow doctors after the fact. That's the relevance of it. And I don't really see how the fact that they're attacking the defense that it's AFE. So
yes, except that we did not present Dr. Edelman as our causation witnesses. And nor did they rely on his
So would you say it was improper to cross-examine Dr. Edelman on that?
Actually, we did object on the cross-examination of the national statistics compared to his guesstimates and the correct number of births, which he had way off.
Well, the
anyway.
hospital could have solved all of this, couldn't they have, by bringing in what the actual statistics were?
And I think that was our point below, that's why we felt it was improper. We would have had to make this whole case over what did Dr. Edelman do properly? Was he diagnosing other cases properly?
Well, I mean, he could have said, I don't know.
Dr. Edelman did, in fact, say he didn't have the statistics and that
he could say, and I don't know, but he didn't.
And
I thought the evidence was he made those statements.
Dr. Edelman testified in a deposition off the cuff. I think I see one or two.
Well, wait, off the cuff. I mean, it's testimony. It's under oath, and he made statement. He could have said, if he did not know, I don't know.
Right.
But he didn't do that. He made the statement.
During the deposition, he also said, I was estimating, hadn't come prepared for all of that, and he also said there were 10 to 20,000 births a year, which was grossly exaggerated as well.
Well, between then and the trial, though, since he obviously knew AFE diagnosis was critical to the case, he could have been able to be prepared to say, I gave that estimate, but I've now gone back and I realized, first of all, there are not 18,000 births at our hospital. There are only 2,200, and even though I thought I was seeing one or two a year, I realized it was only one or two in the last 20 years.
Again, Dr. Edelman, we didn't present him, and he did not do that, and he didn't know how many births there were. He was told at trial, and this was the plaintiff calling him for that. So when we got to Dr. Dildy, in his proffer, he did not, by the way, say, I'm going to opine there's an overdiagnosis. He said, I really couldn't unless I took an independent review of all the recorded incidences and whether there was strong data. And because Dr. Dildy, in fact, was a doctor that had been involved in looking at actual medical records and clinical signs in a registry where they were looking for the classic form of AFE. And he testified, look, we had people from all over the nation submit cases, and we excluded about a third of them. So he didn't rely on any doctor's diagnosis. He does his own independent. He had not reviewed the hospital records. He had not done a statistical analysis.
Well, doesn't that go
all.
to the credibility of what he said rather than the admissibility when he makes a statement about numbers?
No, I think that my point there was that Dr. Dildy's opinion was not based on any statistical analysis of the hospital.
Well, but again, it's based upon his personal knowledge of being an expert in the field is what I thought it was. And certainly it could be attacked. I mean, that maybe he's wrong, but it didn't change what his numbers, what he said the numbers were, did it?
He had the national statistical numbers.
Right.
He had not reviewed Dr. Edelman's deposition testimony, nor had he reviewed the trial transcript when Dr. Edelman had testified.
What does that have to do with admissibility? I'm missing the.
Well,
what's the evidentiary problem? Because he hadn't done that. He cannot express his opinion as an expert on what he knows.
Well, our point is that, and we maintain it was properly excluded because it was talking about something that he had not taken into consideration in his diagnosis. He looked at the clinical facts. And I think that also shows why it's harmless in this case, because again, we had all of the same evidence out of Dr. Edelman. Now, the plaintiff wants to argue that perhaps having an expert reiterate that if this number was right and that number was wrong.
Well, because Edelman couldn't say, listen, when I was diagnosing 1 or 2 a year, I was way higher than the national statistics, which would give me a concern that I was overdiagnosing. That's what they wanted to use the cross-examination of Dr. Dildy for, right?
He did, in fact, Dr. Edelman did, in fact, say if we took, the plaintiff went through and put charts up with all the numbers, and let's assume the hospital interrogatory is right in the 1 to 2 per year. And he was asked to compare those numbers, and would that be as many as 40 to 80 times the national average? Would that be an epidemic? And Dr. Edelman testified, yes, that would be alarming. So we have even stronger than overdiagnosis. We have Dr. Edelman himself saying, yes, that would in fact be alarming. So when we talk about what is Dr. Dildy's, well, if there was recorded incidents as opposed to somebody else's recollection, I'd say maybe over the long run.
I guess to me, even though he made that statement that you just said about being alarming, but his basic testimony was that, I see 1 or 2 of these a year, that we have 10,000 births at this hospital. And so it seems to me that while he may have acknowledged if that was the case, he was basing his opinion, he was making his statements based on facts of 1 or 2 a year and 10,000. And I think it's really different if you have someone else who comes in and says, you have 2,200 and 1 or 2 a year, but that's an overdiagnosis. You don't see that there's a qualitative difference in that?
Well, Dr. Edelman, when he gave those answers, when he was asked for the comparison with the statistics, it wasn't based on the 10 to 20,000 per births. The plaintiff was, in fact, asking, let's take the actual number of births from the interrogatories of 2,200 a year, and what you said you saw 1 to 2. So it was the exact same analysis. It wasn't Dr. Edelman commenting on.
But did Dr. Edelman acknowledge that he was incorrect in saying that the number of births that took place at the hospital and the number of these ASF births that took place?
When he was presented with the actual number of births, he said, yes, I was incorrect. Obviously, you went and got that number. It shows me I'm not a statistician, and I was just guessing, basically. So, but we had all that, notwithstanding whether it's correct or not, and of course we didn't have the records, and he had grossly miscalculated how many births.
He stood by his diagnosis, correct?
Dr. Edelman?
Yes.
Yes, he did. Dr. Edelman did. But he did say we did have an evidence that would be alarming if those statistics were correct based on what you've given me. And nothing that Dr. Dildy could say about, well, if I had a recorded incidence as opposed and strong data, I look at strong data, yes, it would be overdiagnosis. That's not going to change. That's not adding anything else. And plus, Dr. Dildy also said in the proffer, I cannot tell you what the incidence rate is at the hospital. I can't tell you whether it's overdiagnosed, misdiagnosed, correctly diagnosed, unless I undertake a review of all of the cases.
But that wasn't the point of his testimony, as I understood it. It was to address the national standards, and this is what the national statistics show us. Is that our? I didn't think that the point of the question was at all what you just suggested. I mean, okay. So that he's not applying it to exactly what happened here, but this is a question that goes to the basis, the heart of that diagnosis is what I understood it to be. Am I wrong?
Yeah, and maybe I don't understand. He did talk about how rare it is and what kind of criteria they do.
Okay.
And then he looked at the clinical. That's where the national statistics came in.
Okay.
Thank you.
Good morning. May it please the court. Mike Middlemark on behalf of West Boca Medical Center. Sitting and listening to these arguments this morning on criminal law, I know that life and liberty is at stake. What we have in this case is a tragedy. A woman did lose her life at West Boca Medical Center shortly after she gave birth. I don't want to have my comments on harmless error belittle that fact, because that's the bottom line in this case. Their trial, a 4-week trial, did accomplish everything that the plaintiff wanted to accomplish and everything the defense wanted to accomplish. And at the end of the day, if you look at the totality of this evidence, which is what the initial 4th DCA panel did and what the entire en banc panel did, they looked at whether or not there was a miscarriage of justice under Section 59.041.
Well, why don't we, just on the issue of the error, I assume that we adopted, there was no reasonable possibility of an effect on the jury. Can you still make the same argument that because this was cross-examination on a point that really the question of Dr. Edelman's 2 a year was sort of a fuzzy number, that the jury would have heard that and really not made a different decision, because we don't know whether they ended up finding this plaintiff hadn't proven there was negligence, or that the defendants proved it was AFE. It could have been either. So if you want to just address, let's assume the stricter standard. Does it make a difference in this case? Mr. Burlington and his client seem to think it would, or that it should be reversed under either standard. So what's your take on the significance of this evidence?
My take is that even under the reasonable possibility standard that you are suggesting, that there was no miscarriage of justice.
Well, don't use, you see, when you throw in miscarriage, that becomes, miscarriage of justice is a term that we use sometimes with fundamental error. I know it's in the statute.
Thank you.
But we've taken DeGuilio and we've used different language. So let's just stay with there's no reasonable possibility of an effect on the verdict. That's what I'm asking you.
So here we go. Dr. Edelman testifies. He sees 1 or 2 a year. He thinks 10,000 or 20,000 births a year. And then he testifies at trial that he doesn't know.
And by the way, in terms of him saying that, he wouldn't really know how many births a year because he's not an obstetrician. But anytime there would be a diagnosis of AFE or a pulmonary issue, he, as the chief, would be called in. So his estimates on the births would be just based on what he thinks sort of out of the air, but on what he's actually observed as the pulmonologist, it is more reliable, isn't it?
Yes, and just wanted to point out the fact that Dr. Edelman is not an employee of West Boca Medical Center, and West Boca Medical Center was never sued for direct allegations of any negligence. It was strictly vicarious for Dr. Baux.
Well, I mean, we're not getting into. I mean, that's not an issue here. With as I understand, what's raised as to who's responsible for who. I mean, we're really looking at the standard for harmless error.
Right.
And then some other issues and admissibility of evidence. I mean, these questions aren't geared towards who is responsible. It's this evidentiary burden.
Right.
So I think that'd be your best bet to stay with those, because we're not trying to point finger at anybody in our questioning.
Well, absolutely, Justice Lewis. It's just when I hear the phrase "they overdiagnose."
Well, okay.
AFE, West Boca Medical Center
Please
does
answer,
not
if you could answer the
Okay,
question.
we understand that
yeah.
West Boca
Thank
wasn't
you.
sued for overdiagnosis.
Right. So what does the plaintiff produce at trial? They produce Dr. Edelman's testimony. They produce the interrogatory answers, which specifically states how many births are being delivered. And then they hammer in their closing argument the statistical anomaly.
And that was based, though, on they were able to make those closing arguments based on Dr. Edelman's testimony that they introduced.
But also with Dr. Dildy's testimony that the national average is somewhere between 1 in 8,000 and 1 in 80,000. And even Dr. Dildy testified in his cross-examination, let's assume it's 1 in 20,000. So the jury, in addition to hearing the standard of care defense from Dr. Baux and West Boca Medical Center, also had the causation defense. And it's a two-pronged in a medical malpractice.
I'm a little puzzled by that response, because, I mean, clearly the 4th DCA, 4th District, qualified judges, found at least that something had been erroneously excluded. So there's got to be more than what you've said actually came in. Something didn't come in that ought to have. I mean, that's what the court below held. Am I correct?
Yes, you are
Okay,
correct.
so let's
and
go
there's
from
no
there.
argument from West Boca on that.
And it was what didn't come in was the cross-examination that there was 1 or 2 a year, and that would have been an unusually high AFE incidence. And so now it's the proffer that we at least have, and it was great the judge did that, so we actually know what the cross-examination would have been.
Right.
So taking that, the argument I'm asking is,
Sure.
Is there still not a reasonable possibility that it affected the verdict?
Because as we've all read the proffer, Dr. Dildy goes on to say, it doesn't matter whether West Boca Medical Center, there's an overdiagnosis. It's what matters in this case here. And in this case here, it was AFE.
And did he base it, I asked Mr. Burlington whether he based it in part on the clinical diagnoses of the other doctors. Did he base his opinion on what the other doctors had diagnosed?
No, he hadn't even read Dr. Edelman's deposition. He wasn't present when Dr. Edelman
but I
testified.
thought Edelman's diagnosis wasn't in the records?
It was in the record, but
So
you
he
asked
didn't
me...
read the hospital records?
I thought what you asked me was whether he based his opinion on that, and he based his opinion on his independent review plus his education, training, and
No, I understand that, but it wasn't part of what he based it on, what the clinical diagnoses of the doctors right after the incident occurred.
Okay, so the answer to that question is yes, but he also had a plethora of other evidence which the 4th DCA reviewed as they're required to do in any case involving harmless error.
Sure, we look at everything, but then
Everything.
look at what the effect of this cross-examination would have been. And actually, I'm not sure that it would have made much. I mean, that's why I'm sort of asking for both sides of it, that I think they got most of what they needed to get in through both the directive of Dr. Edelman and Dr. Dildy, and I'm not sure what part of the cross really would have affected the jury.
Right, and that's what Judge Levinson found and Judge Taylor found, and then on the en banc panel, Judge Gross found, and even Judge DeMorgan.
Well, they were using, though, remember, that's why about the two different standards. They were using more likely than not, and I think that maybe the panel decision was using but for. And so we're moving, what I was asking you is if we go to even the DeGuilio standard of reasonable, is there a reasonable possibility that it would have affected the jury verdict? You would really argue under any standard it wouldn't, correct?
In this particular case.
Okay. Which is why I'm not so sure these standards make all this much of a difference, because I think appellate judges come to these conclusions. We don't know what the jury found, so we're trying to put our best spin on would this have been the kind of evidence that could have really turned this case around. And we're really, and you say there's a 4-week trial, so we're supposed to look at how the jury saw all the evidence over a 4-week period and whether this bit of cross-examination would have changed, what might have affected the jury verdict.
To quote Judge Levinson at the oral argument on the 4th, this was not a game changer.
Well, he said that, but Judge Farmer said had a different. I mean, again, I think that the issue is it should have come in. Did it make a difference?
Correct. And the en banc panel, the 9 justices from the 4th DCA, unanimously concluded it should have come in, but it was harmless error. And they used the more likely than not standard. They used the section 59.041 standard. They used the 90.104 standard that has got to substantially affect the rights of the adverse party.
But what they did not use was the D'Aquilio standard. Am I correct? Am I correct? That they rejected.
In a civil case,
What?
the
I
4th
understand.
DCA, the answer.
That's what I was asking, is
yes.
does it make a difference? I mean, that's the statute they did not, and under that statute, I'm sorry, not statute, under that standard, the fact that there may be other evidence, even overwhelming evidence, does not escape. If the error has been committed, the party that has committed it is evaluated under whether it contributed to that verdict.
Correct.
And
But
so
they-
there's a question as to, you see what I'm saying? I mean, whether the judges will follow the law is not something that's here. Our job is to announce what that is, and as clearly as possible, so that everybody can follow it. You folks can follow it in the courts. Whether they will or not, I guess, is another question.
But what the 4th DCA did concede is the effect on the fact finder. And that's something that this court pronounced in D'Aquilio and the prior case, State versus Lee.
But it's not a weighing of the evidence. See, when you start talking about, there's substantial evidence on the other side, that's not the D'Aquilio standard. And the law is as long as your arm, isn't it? That says that just because there's substantial evidence the other way doesn't mean that you take a ride on this.
It's not
pretty heavy burden, isn't it?
Well, according to D'Aquilio, it's got to be a reasonable probability. The state has to prove beyond a reasonable doubt that there was no influence on the fact finder, thereby contributing to the verdict, right?
Did not contribute to the verdict.
Did not contribute
Reasonable
to the
possibility that it did not contribute to the verdict.
Correct. And I'm saying, based on everything, looking at the totality of this entire case, not because there was cumulative evidence that there was AFE or wasn't AFE, but looking at the totality, the proffer of Dr. Dildy did not affect the verdict, thereby contributing to the verdict. It had no effect on the fact, whether it's a reasonable possibility standard or a reasonable or more likely than not standard, as Judge Gross articulated. And based on that, I would request that this court affirm the judgment in favor of Dr. Baux and West Boca in this case, and thank you.
Thank you for your arguments. Rebuttal. And you may have an
I just would
additional.
like to make 2 points. One is...
He was about to give you additional time.
Yeah, I was. You
Sorry?
can have another 2.5 minutes on top of what you have.
Oh, great.
Would you answer?
I'll still make it 2.
Would you respond would you respond to their argument?
Okay, thank you.
It makes no difference. It is essentially saying it was excluded, it was there, so what? Because the evidence is so clear.
Perhaps the best evidence of how significant this was the lengths to which they went to have it excluded. They have repeatedly stated up here, which is true, that Dr. Dilby, who was their AFE expert, never reviewed Dr. Edelman's depo. And I have never read a medical malpractice trial where the expert doesn't even read the depo of the doctor who diagnosed the condition as to which he's testifying. This was argued when they tried to exclude the testimony that on appeal, the hospital hasn't even tried to defend the basis for exclusion. And the doctor has made an effort, albeit token, to justify it, but it clearly was legal error. But they did not have him read that depo because they argued, he didn't rely on it, he didn't read it. Well, Well, they did that intentionally because they knew the power of this testimony. And Dr. Edelman does not have to be a statistician to testify his personal experience in the number of times that he's diagnosed AFE. And we got in the number of the total patients, and it's undisputed, who had births there from the hospital's answer to interrogatories. So there's no speculation here. Whether Dr. Edelman was exactly right or not, he's off by 20 or 30 times the national rate.
It just
even if
seems,
cut it in half.
in all the harmless error cases, we had cases where collateral sources came in and we found that reversible error. You've got, in criminal cases, comments on the right to remain silent. What you're really asking us to do is say that because about a page of cross-examination didn't come in a 4-week trial, that even if it was error, that was harmful. And I just can't, I'm having, it's not like something damaging came in that changed the way this case was going to go. It's that some part of the cross-examination wasn't heard. And I'm just having, it's a harmless error and just not reversing for what's relatively, quote, small errors.
Well, Judge,
I'm not seeing, again, so just going back to Justice Lewis's question about, you said they went to great lengths. Well, that's not really the way we would evaluate it. What is it that would have changed the way the jury would have looked at it once they heard Dr. Dildy's cross-examination?
Well, it was the concession that he would have to testify that they overdiagnosed. And I would add that in the context of medical malpractice, in the decision in Lynn v., I believe it's Fossum, which was the one regarding what they called the curbside consult, this court stated that when the critical aspect of the case is the weight of expert testimony, a ruling, in that case admitting erroneous evidence, was harmful. And we cited the Whittam case out of the First District.
Because she bolstered her testimony with saying, I spoke to lots of other people who all agreed with me.
Correct. But it was still cumulative of her opinion, which she adhered to despite cross-examination. In the Whittam case, which was a work comp case, there were a toxicologist and a doctor testified as to causation. They ultimately determined toxicologist wasn't qualified to give that testimony, but there was another doctor that gave the identical testimony. You could claim it was cumulative, but the court reversed. This is a classic battle of the experts, and when their expert admits that these numbers would indicate overdiagnosis, and then he adheres to his opinion, which they claim strengthens their position, we would say it acknowledges that he was locked into this position, was not being reasonable. We don't have to prove a Perry Mason moment. But the only other thing I want to say is that former Chief Justice Traynor wrote a treatise on harmless error, which in De Giulio this court described as the most perceptive analysis, and he also recommended a unified standard, civil to criminal. And so I believe the case law is supportive of that. There are many courts that do not. But I would suggest that this court should review those cases, especially the McQueenie case, because it goes through the various considerations, and if this court deems them to be reasonable, it is a very good basis for concluding that not only simplicity, but in our case, the language of the relevant statutes are consistent and should be applied consistently. And for that reason, we believe reversal is appropriate. Thank you.
Thank you for your arguments. Court is adjourned.